On Wednesday, July 24th, 2024, the Ashley Benefield trial continued with day 2 of testimony. And on day 2, the jury heard from another 8 witnesses. Now, one thing that we can definitely appreciate after some of the other cases that we've covered on this channel is that the prosecution team is moving very efficiently through their case in chief. But even still, some of the witnesses were actually surprising to see called by the prosecution in this case. Now, in terms of what actually came out at trial, I think I would call day 2 a little bit of a mixed bag in terms of success for the prosecution and the defense. But Judge White, on the other hand, continues to impress most of all in this courtroom as a judge who is tough and strict and enforces his rules with purpose, and yet is very fair and very genteel. And on day 2, we saw exactly how he can completely dress down an attorney in the most high-class yet brutal way. He might just be actually one of my all-time favorite judges. Watch until the end to see what I'm talking about. Let's get into it. So the first witness of the day was the state's 9th witness. And surprisingly, the state chose to call Alicia Byers the mother of the defendant, Ashley Benefield. Basically, the prosecution touched on 3 points with Alicia. The first was that when Ashley was pregnant, Doug actually brought Ashley to Alicia in Florida, and he said that she needed Alicia to take care of Ashley. Anyway, then they touched on Ashley's concealed carry license. According to Alicia, she and Ashley actually took the required classes for the license together. Now, the prosecution also asked Alicia if Ashley would go to the firing range often with their next door neighbor, John Sant, the one who ultimately called 911 on September 27, 2020. There was a suggestion that this was kind of a regular thing, but Alicia waffled on the stand a bit and ultimately said that she didn't really know about that. To me, it seemed like she was maybe obfuscating a bit, but it also could be that she was struggling due to the high pressure nature of this environment. Overall, she didn't come across as particularly strong-willed or even that confident of a person. And I'm also wondering why the prosecution wouldn't have asked John Sant about this on day 1. However, like I said in the day 1 recap, the defense has been trying to suggest that Ashley isn't experienced with firearms, as we saw with Taylor asking a couple different witnesses about the round getting lodged in the firearm. Taylor asked expressly if holding the firearm too loosely was something that a neophyte might struggle with. So in my opinion, this evidence about the concealed carry license can potentially cut away from the defense's attempt to illustrate this. Anyway, the final thing that the prosecution touched on with Alicia was the fact that Alicia, Ashley, Emerson, and Doug were all planned to move to Maryland at the same time and in the same moving van. And in preparation for that, Alicia said that Doug came over like every day for a week to help them move. Then on September 27th, 2020, Alicia was leaving with Doug and Ashley's daughter Emerson to go to the park in the early evening when Doug showed up. Emerson was approximately 2 years old at the time. And as for the shooting itself, Alicia agreed that she's been in contact with Ashley basically every day since the shooting, and Ashley has never told Alicia what happened during the incident. Now, there was a cross-examination of this witness, but honestly, nothing crazy came out here. The park was a 5-minute walk away from the house, for example, and Alicia would regularly take Emerson around that time because earlier in the day it was just too hot. Really, nothing crazy. Anyway, the state's 10th witness was Dr. Barbara Russell. She's a licensed clinical social worker and works as a clinical health professional. She said that she's known Ashley since April 2020 when she met her in a professional capacity. And since then, they've become more social. And after the shooting, Ashley even moved into her house with Dr. Russell, her husband, and her 19-year-old daughter. Ashley apparently lived there for 8 months, and so Dr. Russell would see her on a daily basis. Now, immediately after the shooting happened, Dr. Russell said that the first time she spoke with Ashley was at 1 a.m. the next morning. However, apparently Ashley did not discuss what had happened at all, nor did Dr. Russell ask, apparently. So what they talked about at 1 a.m. on the day after this all happened, I have no idea. But apparently to this day, Dr. Russell says that she's still in contact with Ashley, but says Ashley hasn't told her any kind of narrative as to what had happened. So honestly, although the prosecution has been very efficient so far, I do struggle to see what the jury is supposed to take from this particular testimony because it felt like a whole lot of nothing. The good thing about it, though, is that it was relatively short. I know that there was apparently a really big hearing about Dr. Russell's testimony and whether or not she could testify about the circumstances involved in Ashley living with her for that period of time. So I'm wondering wondering if there is some portion of the prosecution's questioning that just got gutted by the judge's ruling after that hearing, maybe. But now in cross-examination, there was one thing that came out that was interesting, and this had to do with that 1 a.m. meeting that Dr. Russell had with Ashley after the shooting. Dr. Russell testified that she was able to see Ashley's face and that she said that she had a large edema, swelling, on the left side of her face to include her left eye. She testified that Ashley didn't have that swelling the last time that she had seen her. And she testified that Ashley also complained about having a headache. So of course, this is evidence to support the idea that Doug did in fact violently hit Ashley upside her head on September 27th, just prior to the shooting. Anyway, the state's 11th witness was Lieutenant Daniel Dickerman of the Manatee County Sheriff's Office. In 2020, he was the senior homicide investigator assigned to the Manatee Homicide Investigator Unit. And on the day of the shooting, he was notified between 7:30 and 8 p.m. about what had happened, so he went to the scene. When he arrived, Ashley was in the back of a patrol vehicle, and he spoke briefly with Alicia, her mother, who then also spoke with Child Protective Services. Although he said that she answered most of their questions, he said that she wasn't actually all that cooperative with them. And other than this, really the only thing that he really testified about was the fact that he searched for videos of the park around the time of the shooting, as well as any sort of ring footage at the house. He testified that he did find some surveillance footage of the park and that it did indeed show that Alicia and Emerson were at the park at the time of the shooting. But, curiously, the state did not introduce any of this footage through this witness, let alone show any portion of the footage. And as for the ring footage, he said that he found some, but it only captured the arrival of the U-Haul truck and then eventually the deputies in response to the 911 call. So the ring footage feels like a bit of a nothing burger, but I guess this is to show that the police did do a full investigation. At least that's what the prosecution wants the jury to conclude. Now, in cross-examination, the defense focused on 2 points. The first point was that it takes time to determine criminality and that comes from a full investigation. This was basically to address the fact that the police call an event like this a homicide from the get-go. It doesn't necessarily mean that they've determined criminality at that point. And second, he pointed out that the crime scene that was preserved was not necessarily how the crime scene appeared before the first responders arrived. And the reason for this is because the first priorities when first responders arrive at a scene is to take life-saving measures, and then only after that point do they have the second high priority of preservation of evidence. This is typical in any kind of a criminal case, but it does bear mentioning for the jury. Okay, so the 12th witness was Stephanie Murphy. She was Doug's family law attorney since March 2018, so she actually saw a lot of the back and forth between Doug and Ashley, and obviously this was from Doug's perspective. One thing that she said was that Doug was never really angry or aggressive, and in fact, sometimes it was a bit of a point of contention in their working relationship that he was actually maybe sometimes too mellow. Anyway, she said that Doug initially hired her to draft a letter to Ashley to initiate talks about Doug's participation in the baby's life, to include hopefully being there for the baby's birth. She said she sent this in an email to Ashley on March 15th, 2018. However, Ms. Murphy said that Ashley never responded, and as she later found out, the next day Ashley had actually checked herself into the hospital to be induced. And so the baby was born on March 19th, 2018. However, Ms. Murphy said that neither she nor Doug knew that the baby was born until May 6th, when Ashley filed a petition for protection against DV, requesting an injunction against Doug. In that filing, Ashley identified the date of birth and the name of the baby, so that's how they found all of this out. Now, in response to Ashley's petition, the judge denied her request for a temporary injunction, but set a hearing for further evaluation. And at the same time, Doug also sought to establish a parenting plan for sharing time with Ashley for being with the baby. And so the injunction case and the parenting plan matter were paired as related cases, although they technically were separate. Now, when it came down to the hearing, Ashley had alleged that Doug was violent towards her. For example, she alleged that he fired a gun in the air, that he punched their dog, and that he was poisoning her with heavy metals while she was pregnant. And this is interesting because these allegations, like I said on day one, are extremely serious, and if true, pose a serious hurdle to the prosecution's case here because they are strong evidence that he was in fact abusive towards her. However, it's interesting to note that a family law court already heard these allegations and still made a determination against Ashley on the matter. Particularly, the judge decided to deny Ashley's request for an injunction, and they ruled favorably towards Doug for the parenting plan. Specifically, the judge entered a ruling for a time-sharing schedule on a temporary basis between the two parents, and they ruled that Doug had ultimate decision-making authority over Emerson's medical decisions, and that otherwise the two two parents had shared decision making. Now, of course, this could be interpreted in two ways. Either the judge looked at Ashley's allegations and the evidence that she had to back it up and properly found out that she was basically making all of this up, or the system maybe failed a DV victim. Judges can get things wrong after all. I've been vocal in my own disagreements with judges over the course of covering cases on the internet. So what specifically this says about this situation is probably up for interpretation. Anyway, within days of this ruling, Doug met Emerson for the first time. And she was around 6 months old already at this point. Ms. Murphy testified that she was there at the sheriff's office for the exchange, and she said that it actually was a little weird. She said that they interacted awkwardly for a bit until Ashley finally let Doug hold Emerson. And then when it came time for Doug to have his time with the baby, Ashley said that she actually wanted to go with them. And Doug then agreed. Now, Ms. Murphy said that this was crazy because they had just gone through protracted, knockdown, drag-out litigation over this whole situation. And now, after all of that, they were all going to go and spend time together like some happy family. It was weird. Ms. Murphy said that she cautioned Doug about going with Ashley, and she said that it was a risk, so she advised against him allowing Ashley to go with them. Doug, however, said that he understood her concerns and said that he was going to go and do it anyway. And then, within a week, the two decided to expand the time sharing for Doug than what the judge had even outlined. This new agreement that they entered into took away other restrictions too, like, for example, having to meet at the sheriff's office. And so then Doug and Ashley were in continuous conversation until August 16th, 2019. And according to Ms. Murphy, Doug was supposed to move in with Ashley and Alicia at this time. But now, Doug and Ashley were no longer speaking to each other at this point. And what came next was a petition for divorce on November 5th or 6th, 2019. And following this filing, Ms. Murphy said that she also got information within a month about a series of complaints against Doug, which also became the basis for a new injunction request made by Ashley. And then there came the requirement that Ashley get a psych evaluation. Ms. Murphy said that it wasn't court ordered, but that this was recommended due to another matter and that both sides agreed on this. And so the next thing that was set to happen was a hearing on September 30th, 2020, 3 days after Ashley ultimately shot Doug. Ms. Murphy testified that the only purpose of the September 30th hearing was to release the report for the psych evaluation. And so it is her position that this shooting happened to prevent the results of the report coming to light. Now, in cross-examination, the defense pointed out that the psych evaluation report actually evaluated both Ashley and Doug. And then the defense tried to fight Ms. Murphy on the idea that Ashley shot Doug to prevent the report from coming out on September 30th, but to me, he didn't quite land where he was hoping. Taylor got Ms. Murphy to agree that this hearing wouldn't happen without the presence of Dr. Broeder, the clinical psychologist who did the evaluation. But then Taylor tried to say that Ms. Murphy knew that Dr. Broeder was out of town on September 30th, and that this means that there was no way that this hearing was going to be about the psych evaluation report. But when he tried putting email receipts in front of her to impeach her, showing correspondence on the subject between her and Dr. Broeder's assistant, she pointed out that this vacation time that was the subject of these emails was about a potential hearing on September 23rd, not September 30th. And so she said that this was precisely why they set the hearing for the 30th instead of the 23rd. Taylor seemed adamant that she was wrong about that, and he was fighting her on it, but she was sitting right there with the email right in front of her saying that's 100% not correct. So here we have another example of Neil Taylor, the defense attorney, trying to impeach a witness with receipts, but doing so with receipts that don't say what he says they say. And the thing is, this can start to set a pattern for the jury that this attorney isn't really all that attuned to important details that he's trying to fight over. It may not ultimately decide the case, but in a trial where inches can really matter and perceptions can be shaped, this can end up playing some kind of a role. Anyway, there was one more thing that the defense pointed out on cross-examination, and this was about a package that Doug sent to Ashley in November 2017. Apparently, on November 3rd, 2017, a South Carolina court ruled on a mutual restraining order between Doug and Ashley. But not long afterwards, Doug apparently sent Ashley a birthday present in a package through the mail. And so this, in fact, is a violation of that restraining order. However, Ms. Murphy defended this by saying that this was after the hearing, but before the judge signed and sent the order from the hearing. And she said that Doug didn't fully understand what was going on at the hearing, all of that kind of cleared up for him much later. So again, multiple interpretations are possible here on this one. Okay, so the next witness was Detective Chris Gillum. He's a domestic violence investigator from the Manatee County Sheriff's Office. And he had some interesting testimony about Ashley. He said he first became familiar with her in December 2017 when she reported Doug for violating the South Carolina injunction. Then in February 2018, he said that she began contacting Detective Gillum regularly, calling at least 2 times a week, asking about the status of the case and when they would arrest Doug. At some point, he notified her that they had forwarded the charges to the state's attorney's office. And he said that in response, she was not happy that he was not getting arrested. Then, in May 2018, they had a phone conversation that is very important to the prosecution. In this phone call, she mentioned a court hearing and she requested that he arrest Doug at the hearing and specifically while Doug was standing in front of the judge. When he responded that he would absolutely not be doing that, he says that she got hysterical. And then she said, well, if the judge sees you arrest him, maybe he'll let me keep my baby. And so then he testified that he explained to Ashley that that is not at all how any of this works. Then they went back and forth for about 5 minutes, and he says that her tone suddenly turned aggressive, saying, "You will effing arrest him in front of the judge, and I will make sure you do it." He said he pushed back and said, "You can't make me arrest anyone ever, let alone anyone in front of a judge." Then she started crying again and said something like, "I can't believe you're willing to let Doug kill my baby." Detective Gillum testified that this conversation was about 20 to 30 minutes up to that point, and she didn't seem to understand the process. And then at that point, her crying abruptly turned into a high-pitched scream or screech, and she said, "I'll do whatever I have to do to keep my baby, a-hole." He said that at that point, he basically started to check out of the phone call, and she accused him of conspiring with Doug to get her baby taken away from her. Ultimately, this phone call ended when Ashley terminated it. Now, he said that he remembered this phone call very clearly because he had never had anyone ask him specifically to wait to arrest someone until they were standing in front of a judge. Now, the one thing that does call this into question is the fact that Detective Gillum wrote a number of supplemental reports over the matter, and this included a report that he made after the May 2018 phone call. And what came out on cross-examination is that in the initial supplemental report, he did not include any of these details about her statements that were to the effect of, "I'll do whatever I have to do to keep my baby." Instead, he wrote about this in a separate supplemental report after Doug died, having learned about the details of that case. Importantly, this was now 2.5 years later, so there is a valid question as to how accurate his memory is about these statements that she allegedly made to him in May 2018. However, his response was that these particular statements stuck with him because, like I mentioned earlier, he said that he had never had someone ask him to arrest someone else specifically in front of a judge before. And he said that the reason why he didn't put them in the report was because at the time, these statements didn't mean much to him. He figured these were just indications that Ashley was going to do whatever she could to manipulate the legal system to get what she wanted. But then when he learned that Ashley had actually shot Doug and killed him, this new information gave new meaning to these statements, since now Detective Gillum understood them to be threats to Doug's life. So the way that you see how this potentially shakes out, does that end up satisfying the defense or the prosecution, is likely up to your interpretation. Okay, so the state's 14th witness was Detective Brian Moreland, a detective for the Crimes Against Children Unit, or CAC unit, at the Manatee County Sheriff's Department. Essentially what he said is that after a report comes in involving a child, the police will do an investigation initially, and then Detective Moreland will do further investigation once it's referred to the CAC. For one thing, he testified that he actually happened to be there when Detective Gillum had that May 2018 phone call with Ashley. And although it sounds like he didn't hear the specifics of what actually Ashley had said on the phone call, he did testify that he remembered that Detective Gillum was exasperated at the end of it. Then Detective Moreland became familiar with Ashley himself since she made some child abuse allegations against Doug beginning in December 2019. Specifically, there were 3 different claims that were made. On December 10th, 2019, she alleged that Doug S.A'd Emerson. Then on March 21st, 2020, she alleged that Doug had physically abused Emerson. And then on March 23rd, 2020, she made another physical abuse claim. Now, after the CAC investigated these claims, no charges were actually filed on any of them. And again, how that cuts could depend on your interpretation. Was this evidence that she was lying, or is this evidence that the system has simply failed her? But what ultimately came out of all of this was that Child Protective Services assigned both Doug and Ashley to go to therapy with Dr. Broeder, who is the clinical psychologist who ultimately put together that psych evaluation report. And speaking of which, the state's 15th witness was clinical psychologist Dr. Brad Broeder. He apparently has his own practice, but he also does work as a consultant for the Manatee County Sheriff's Office for their child protection cases. And because of that, he was asked to do a psych evaluation of Doug and Ashley. He said that the Manatee Child Services had some specific things that they wanted him to go into for the evaluation of each parent, but he didn't really go into what exactly that was. And he said that generally speaking, the evaluation is geared towards the best interests of the child. Now, for this evaluation, he said that he talked to them both together and separately. And he apparently also did collateral interviews where each person gives him references of people to talk to. These are people in their social circle, for example, who can give more of a contextualized picture of each individual that he's examining. And he said that he would also interview them when they did a drop-off of Emerson, particularly at the sheriff's office. He said that all of this happened throughout the summer of 2020. He testified that Ashley never showed any hesitation to talk to him when Doug was present, but she acted differently depending on whether Doug was there or not. For example, when together, Ashley made it very clear that she was moving to Maryland. Doug said this was something that he also hoped to be able to do since he had connections with the DOD that he was hoping to establish some business with, and he said that he was looking at that as an opportunity for a fresh start. Doug also expressed hope that this would be an opportunity for reconciliation. Now, in his presence, Ashley never really corrected that response, and she would typically respond deferentially to him, basically let him say whatever he wanted to say. And Dr. Broeder testified that the closest that she would ever get to essentially contesting him was that she would sort of deflect away from that conversation, saying things like, well, we can talk about that later. However, when Doug was not there, Ashley made it very clear that she did not want Doug to move in ever. She indicated that she was running out of time to move to Maryland. And she said that she felt frustrated with the whole court system, the local sheriffs, and that she needed to get this over with so that she could get on with her life because it was in shambles and everything was just taking too long. She also made it privately clear to Dr. Broeder that she had no intent to actually reconcile with Doug. But then when they were together, they shared a very different picture. They showed that they would go on dates together, for example. They'd go for dinner, they'd see movies. They saw Tenet apparently twice because they were both confused by it the first time, which is completely understandable. And they would take Emerson to the pool together. However, on the subject of Emerson, apparently Ashley said that she thought that Doug was unfit to parent Emerson and that he was just basically using Emerson to get back in Ashley's good graces again. And she admitted to Dr. Broeder that she did not inform Doug when Emerson was born. And she said that when Emerson actually was born, the last name that Ashley gave Emerson was Caney, Ashley's grandfather's family name. Apparently she said that she did this because she wanted to continue her grandfather's family name, but she and Doug were later discussing changing the name from Emerson Grace Caney to Emerson Caney Benefield. Anyway, Dr. Broeder testified that he submitted his report to the Sheriff's Department on September 14th, 2020. And a couple days later, Ashley showed up in the waiting room unannounced, wanting a copy of the report. Dr. Broeder testified that he had to explain to her that he couldn't just release it to her, that it had to be released by a court order. He said that she seemed very frustrated and she talked about wanting to move on with her life and just wanting to know what the results were. And then she said something that Dr. Broeder found interesting. She said that after she established residency in Maryland, after 6 months, she'd be able to go through the court system there to get exclusive custody of Emerson there and essentially take matters into her own hands. And he said that that was the last time that he saw or interacted with Ashley. His direct examination ended with him testifying that Ashley never said anything about Doug physically harming her or that she ever had any concerns for her own safety, only concerns about Emerson's safety. So this can be interpreted as an inconsistency. Was she really afraid of Doug for herself and just not expressing this to Dr. Broeder? Or did she actually only fear for Emerson's safety? And is that something that just sort of changed over time in terms of who she told what. This also lends to the question of, was she a DV victim or was she moving the goalpost, because these kinds of allegations can be wrongly used as a tool in these kinds of custody battles. Was she being duplicitous to get what she wanted, or was she walking on eggshells around Doug for fear of her safety and the safety of Emerson and just trying to find a safe way out of the relationship? I will say this case is a really, really tough one so far. Let me know what you think in the comments down below. Anyway, the last witness of the day was Dr. Jason Quintal. He is a mental health counselor and saw Doug and Ashley in a series of couples visits starting on June 15th, 2020. And he said that the goal of these visits was trauma resolution treatment. He testified that they had a series of couple sessions together and then other sessions where they came in individually. And like Dr. Broeder, he testified that Ashley was one way when Doug was there and another way when Doug was gone. When they were together, the goal was to unify and move to Maryland. However, when Ashley was alone, she was more descriptive of things that happened between them that she apparently said were scary to her. She also questioned whether she wanted to stay with him or not. He said that there were actually many things that got brought up and she was discouraged with how long everything was taking. He testified that she was concerned about Dr. Broeder's report and feared that if something bad about Doug came out of that report, he would get angry and find some way of retribution against her. And honestly, this came out during the prosecution's direct examination, and I think this tidbit does cut against the prosecution's case here. The prosecution says that she was concerned about what was coming out in the report and she wanted to prevent that from coming out. However, if she was concerned about what was coming out in the report, but said that she wasn't concerned about her information, but rather Doug's information, it seems strange that this would be a basis for her to murder him. Rather, this does sound, to me anyway, like the logic of a DV victim. If something bad comes out about my abuser and they get angry as a result, they might say that it's somehow my fault and then hurt me or our kid. Of course, she could just be saying that. But based on the way that this came out, there's no suggestion here that the statement that she made to Dr. Quintal was somehow deceptive or manipulative. So to me, it does sound like it's likely an accurate way that she was in fact feeling about this report. Anyway, the cross-examination of Dr. Quintal was very short and there wasn't much on an evidentiary level that really came out. However, Neil Taylor, the defense attorney, stepped on a landmine when he made a certain quip in front of the jury during this cross-examination. And Judge White showed that although he is very kind and genteel and soft-spoken in his manners, he is not a judge that you ever want to mess with. Specifically, here's what happened on cross-examination that led the jury to be excused so that Judge White could give a certain addressing to the defense attorney.
Tell us why, when you met with them, Ashley was different when she was alone and when she was together with Doug in meeting with you.
So Ashley presented that she was concerned about Doug. There was prior acts of violence, shooting a gun, no
sustained.
Not going to get into specifics.
Okay, without... Yeah. Oh, you have no idea. Without...
Why don't you go ahead, excuse me, Deputy, would you please go ahead and take the jury out? Mr. Taylor, is there anything you'd like to share before I begin speaking?
I think I'm about to catch a whooping. I'm not quite sure why, but go ahead.
I believe that you expressed you're a veteran of over 400 jury trials.
Yes, sir.
This is all rhetorical. You can feel free to answer or not answer. My assumption is that you're familiar with trial process and procedure, that you're familiar with, as you had mentioned earlier, the rules of professional conduct and decorum. I'm also sure that you realize that if this court makes rulings that you disagree with, whether it's a passing disagreement or a fundamental disagreement with a ruling, I would imagine you're aware of the fact that if ultimately your client is convicted, either you or another attorney or a public defender, if she's indigent, will have every right to appeal to the Second District Court of Appeal every decision I've made from the minute I sat down in this division and started making decisions in this case, all the way through the end of the case. I also would imagine that I'm not the first judge that has made rulings that you disagree with. I would imagine I'm not the first judge that you have looked at up here and said, where in the world did he or she get that from? I would hope that you have not engaged in the conduct like you just did. It was inappropriate. It was unprofessional. We're going to take just a few minutes break. I have this position and I understand criticism. And I expect that. I have often said that I think my job early on as a youth sports referee and umpire prepared me well for the criticism that comes with the job. However, those sorts of side comments are just, they're not appropriate, and I would caution you, sir, not to do that again. That's extrajudicial matters that have nothing to do with the case or the consideration of the jury. All right, so we'll take a 5-minute break and we'll be back.
So I will say that was painful to watch. But although I have empathy for any attorney finding themselves in the position of Neil Taylor here, to include Taylor himself, I have to say I have so much respect for Judge White here. He is so measured and always so fair, and every time he addresses the witnesses, the jury, anyone, he shows the utmost kindness and respect for them. But this interaction here shows that he also demands the same level of respect from the attorneys in the courtroom, not just for himself, but for the process as a whole. And the way he goes about putting the attorney to task for stepping out of line still manages to maintain high class, and that to me is just so impressive. I guess the thing I like about it most is that it's a prime example of the fact that you can be very kind and warm while still maintaining strong boundaries, and it doesn't mean that other people get to steamroll you. Anyway, I do feel bad for Taylor here because we've seen other trials where attorneys have done far worse in the courtroom and definitely gotten away with it. But this also goes to show that when you are operating in a courtroom, you have to learn the boundaries and you have to operate according to the rules set in place by the judge. So if you have a judge like Judge White who is not going to tolerate any amount of spice like that, it is the job of the attorney to work within those rules and figure out how to use them to your advantage. Anyway, at this point, I'm overall still so undecided on this case. It definitely seems to me at this point that at a minimum, this relationship was so toxic, and it really is a tragedy all the way around that they ever met and even started this relationship in the first place. It does seem to me that there likely was manipulation, maybe even abuse, and that this may have gone both ways in the relationship. However, what that means for Ashley Benefield's guilt or innocence at this point to me still remains very unclear. But those are my thoughts. What do you think? Let me know in the comments down below. Otherwise, I hope you enjoyed this or at least found it interesting or informative. And if you did, I would love it if you could hit the like button. It does help us with the YouTube algorithm gods. And if you're new here and you want to see more daily recaps of this trial or more coverage of crazy cases and other interesting legal topics, be sure to hit the subscribe button and the notification bell so you can find out when the next video is out. And if you're really loving the content and you want to know how to best support the channel and get perks like early access to non-trial recap videos, consider becoming a member of Bite Club. You can join either through YouTube memberships or by becoming a supporter on Patreon. Links to both are in the description below. Otherwise, see you on day 3.